of India. And today I am so honored to introduce a designation who administers the oath of office to the President of India. Welcome, sir. Welcome to this webinar. We are so fortunate to welcome the 45th Chief Justice of India, Justice Deepak Mishra. Sir, you had a tenure of 13 months, and during these tenures, you took decisions which will shape this country not for decades, but for centuries. Who can forget the 1993 Mumbai serial blasts where you confirmed the capital punishment? Similarly, during the Nirbhaya hearings, you finally put a stamp on the decision of the High Court. Sir, you are behind solving the 120-year-old dispute regarding the Kaveri River. Not only that, the Ayodhya judgment, which is internationally acclaimed, I must tell the audience that a foundation stone to this judgment was laid by none other than Honorable Justice Deepak Mishra when Sir rejected third-party intervention in the Ayodhya judgment. Not to mention 377 IPC, sir, when you quoted, "I am what I am, so take me as I am." Your statement has become very popular when you quoted this in the 377 case. Well, sir, the country thanks you for the freedom of expression when you permitted Padmavat to be released all over India despite all the protests. Sir, the entire country enjoys the national anthem in the theaters, and none other than you are behind that judgment. Not to mention Section 497 and so many other cases which have laid the foundation for this country's legal system for centuries to come. The country is obliged to your lordship. Thank you so much for coming today. Before I close, recently my college has published a book called Courtroom Number 1, and this book is primarily based on your judgments. So we would request you to inaugurate this book whenever it comes out in print. Thank you, sir.
For security purposes, we will be muting everybody and then I'll unmute only the speaker. So, can you unmute yourself? You must be receiving a pop-out on the screen.
I've done it.
Yes, sir. Thank you. You can start, sir.
Okay. Ladies and gentlemen, I have chosen this topic because I have always felt that the younger generation must appropriately understand and grasp the spirit and the quintessence as regards the fundamental duties. It is noticeable that the Parliament deliberately used the word fundamental while introducing this chapter by way of 42nd Amendment in 1976. As chapter 3 commences with the word fundamental, similarly, this chapter, which forms the subject matter of Article 51A, uses the word fundamental duties. It basically means, though these duties are not that way enforceable, yet they are quite fundamental for nation building and for developing the individual character. Some people might be under the impression prior to 1976, there was no concept of fundamental duties in our Constitution. To erase that impression, I will only quote one line from a 1969 judgment. The name of the party is Chandra Bhavan Boarding and Lodging, Bangalore versus the state of Mysore. There the Supreme Court said, it is a fallacy to think that under our Constitution, there are only rights and no duties. This is an extremely poignant line because the court felt when you are enjoying the benefits of fundamental rights or when you are asserting your fundamental rights, there are duties which are related to them, though not spelled out. Therefore, we must, as quickly as possible, eradicate the impression that there was no idea of fundamental duties before Chapter 4A to the Constitution was brought in by way of amendment. I would like to emphasize on certain facets and aspects of fundamental duties. I do not intend to go in seriatim and explain to the students because my intention is singularly to address the students because they have to learn. Now let us take Article 51A, Clause D. You may ask me, why do I choose this clause? But look at the expression, look at the purpose. It reads, to defend the country and render national service when called upon to do so. So there is a duty cast on every citizen to defend the country and render national service when called upon to do so. So far, such a situation has not cropped up, but there is a constitutional expectation that every citizen must be mentally ready to serve the nation when it's necessary to defend it. Please read D along with C, and one can appreciate the conceptual chronology. You may ask me, why did I read D first and not C? When I read D, you get the inspiration, and when I read C, you have the idea why do you get the inspiration. C reads to uphold and protect the sovereignty, unity, and integrity of India. First, the nation must exist as a nation. And in that context, you have an obligation, a duty, albeit not legal, to maintain the sovereignty, integrity, and unity. Now, why is it so? You are expected to love your country. It is the cry of the place where you are born and grown up that fosters and nurtures you. In this context, I may take you to a description in Ramayana. After Lord Rama defeated Ravan, and there was no other enemy in existence, Lakshman tells Rama, brother, we can stay back. Replies, Appi Swarnamayi Lanka. Read like than heaven. Look at the feeling. Be always in readiness to serve the motherland. Now, having said about the motherland also requires something else. We do not intend to have barren land. We want the citizens to work for ecological balance, the environment, and that too, the wildlife. Environment would include each and every kind of plant and tree. There are statutory laws. If they are violated, punishment is provided. That is another aspect. But your duty, let me read that part. To protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. So it includes living creatures, wildlife, lake, river, and other associated environmental concepts. The Supreme Court has been highlighting on the sustenance of environment since mid-80s. In 1988, the Supreme Court said that there should be 1 hour teaching in educational institutions with regard to the protection of environment and the duties associated with it by the citizen. The court felt an idea planted in the childhood would carry a lot of sense, meaning, and spirit, and they would nurture that when they grow up. The court also suggested that the teachers should be given some training for that purpose, and all this were to be done throughout the country. This shows the involvement and the concern of the court in ecology and the relevance of this part of Article 51A. Now, I may shift a little. A new article was added in 51K. It reads, who is a parent or guardian to provide opportunities for education to a child, or as the case may be, what between the age of 6 and 14 years. Now, this has been introduced in 2010. And you have to associate it with Article 21A of the Constitution, which casts a duty on the state to provide free education to the young boys and girls of that age. The Parliament has also framed Right to Education Act. We are not on the subtleties or the nuances of that legislation. There is a fundamental right, and simultaneously there is a parental responsibility on the parents. In 2005, I was participating in a workshop. Someone said that either on either in fifth or sixth decade of last century, the in Great Britain it was made compulsory that the parents should send their children to the school. There was no idea at that point of time that the parliament will bring in a constitutional amendment or, for that matter, incorporate a fundamental duty. At that point of time, I was reminded and I said, Kautilya or Chanakya, in his Chanakya Niti and other texts, categorically prescribes it is the legal duty of every father to send the child to an educational institution. It was compulsory. Things change with time. We lost touch, but he prescribed this as a niti. And as you know, certain nitis are admonition, and certain nitis, if approved by the court of the king, became the rule. As I have read, this became a rule during that period. Now, I must read out to you a few passages from a judgment in 2009. What does it say about this importance of education and how it is paramount for the growth of a nation? That is in Avinash Mehrotra case. The court says, and I quote, education today remains liberation, a tool for the betterment of our civil institutions, the protection of our civil liberties, and the path to an informed and questioning citizenry. Then as now, we recognize education's transcendental importance in the lives of individuals and in the very survival of our constitution and republic. After saying this, the court refers to Article 21A and also contrasts it Article 51K. That paragraph is very significant, and hence I read. Unlike other fundamental rights, the right to education places a burden not only on the state, but also on the parent or guardian of every child and on the child herself. It directs both burdens to achieve, the Constitution directs, and the compulsory education of children, free from the fetters of cost, parental obstruction, or the two articles also balance the relative burdens on parents of, and the state. Parents sacrifice for the education of their children by sending them to school for hours of the day, but only with a commensurate sacrifice of the state resources. The right to education then is more than a human or a fundamental right. It is a reciprocal agreement between the state and the family, and it places an affirmative burden on the participants in our civil society. Look at the words used. The court has elevated it to a human right, a reciprocatory arrangement between the parents and the state, and the value of education is of transcendence because it liberates civil institutions and civil liberties and enables the citizens to be informed and a questioning citizenry. Please mark these two words, a questioning citizenry and informed citizenry. Now let us connect this informed and questioning citizenry which the education provides with the Article 51A H. It reads thus: to develop the scientific temper, humanism, and the spirit of inquiry and reform. Now there is the word inquiry. I am conscious that the court was not interpreting sub-article H. Court was dealing with parental participation, right to be educated, fundamental duties of the parents to send their children to school. But I will emphasize on the attitude, the culture, the learning of inquiry. I'll tell you why. You must have heard of Arnold Toynbee. Toynbee had written the book Glimpses of World History. That has caught the attention of the educated world, people who are interested in history. The press was very keen to talk to him. So one day he was available. Many members of the press asked one singular question: Mr. Toynbee, why did you toil for 35 years to bring out these volumes of history? Arnold Toynbee was a very wise man and a man of great wit. He replied in one word. He said, curiosity. And that answered everything. Now, this education makes one curious. And when you are curious, you make inquiry. And when you make an inquiry, you get better informed. And a better informed citizen is a good citizen. And that is why Kofi Annan says, who is a good citizen? He emphasizes on education. He says in a single line, a good citizen has to have education and education. In this regard, I may also reproduce a line from him. It's spelled Hinckley. Hinckley says, every good citizen adds to the strength of a nation. Look at the combination of fundamental rights and look at the development of a citizen and ultimately the growth of a nation. I do not mean only economic growth. This growth conveys intellectual growth, mental capacity, love for the country, and development of scientific temper. There are other aspects also. Now, this scientific temper has to be appropriately understood. The medieval history really imposed a lot of superstitions everywhere in every society. It is difficult to tell how people develop these concepts of superstition. There is a book which writes that the people became good observers, and if they found that incidents keep on occurring, especially the bad incidents on certain situations, they felt these kind of situations are evil. And then the idea of superstition grew, that this is bad, this is a bad omen, and you must avoid it. Scientific temper educates you to develop a sense of analysis, an attitude of reasoning, a capacity of rationality. And this scientific temper, I would like to add, is not devoid of spirituality, because spirituality, you will get not the term, but in a different way in subarticle F. Let me read it out to you. To value and preserve the rich heritage of our composite culture. Many people have not understood the composite culture of India. It is difficult. I will narrate a part of history in this regard. In the pre-independence days, the ICS officers used to get training in England. Sometime in the first decade of last century, the British government invited Max Muller to teach Sanskrit and culture to the trainees. The trainees came from various backgrounds, and they were surprised that Max Muller has been invited by the ruling government to teach them Sanskrit and culture. The Max Muller told them in the first lecture that if you intend to learn certain things about India, you must appreciate the culture and you must read this language. Then he went on, I am not giving any kind of emphasis on any language. I am saying that's also a part of composite culture. Max Muller was an authority on that language from the Western world, and he said that. That was his view. A composite culture takes every cultural facet of every community, and the fundamental duty prescribes to preserve the rich heritage of this composite culture. The duty of the modern generation is to see that this heritage is maintained and sustained. Sometimes some younger people are critical of the fact why this particular pantomime is being shown, why this dance being shown. But they should remember the pantomime or the dance is an inseparable part of our composite culture. I have given some examples, only say that they are sustained. They are sustained by government patronage as well as by some enthusiasts. Now let us come to another sub-article, that is E. E is a very significant sub-article. I'll read it out for you. To promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of women. It expresses the expectation in no uncertain terms. It requires harmonious coexistence, tolerance, brings the idea of fraternity from the preamble to our constitution, and it emphasizes that you must renounce, look at the use of the word, renounce the practices derogatory to the dignity of women. As far as the tolerance of each other, I am of the strong view that there has to be peaceful coexistence. We must love each other, and we must have the sense and the sensibility to appreciate each other. As far as renouncing the derogatory practices, I will only apprise you with regard to one authority. You see, all of us have an impression that Mumbai's film industry must be an extremely modern field or area. A case came before the Supreme Court where ladies were allowed only to perform as hairdressers, not as makeup artists. There is a distinction between the two. A male could become both, but a lady could only. She was prohibited to become a makeup artist. When the matter came, the court allowed the writ petition preferred under Article 32, and they said women are entitled to become makeup artists. That is the ultimate result. But the name of the party in that case is Charu Khurana. I'll read a passage. The court referred to clauses E and J. J discusses about excellence. I'll come to excellence. The paragraph reads thus: on a condign understanding of clause E, it is clear as a cloudless sky that all practices derogatory to the dignity of women are to be renounced. Be it stated, dignity is the quintessential quality of a personality, and a human frame always desires to live in the mansion of dignity, for it is a highly cherished value. Clause J has to be understood in the backdrop that India is a welfare state, and therefore it is the duty of the state to promote justice, to provide equal opportunity to all citizens, and see that they are not deprived of by reasons of economic disparity. It's also the duty of the state to frame policies so that men and women have the right to adequate means of livelihood. It is also the duty of the citizen to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. Unquote. The quote meant there has to be achievement of individual excellence, collective excellence, and there cannot be disparity. And you have to, it's a derogatory practice. Of course, the court placed reliance on Article 14, which deals with equality. It's discriminatory, but court also referred to the same. The purpose of my saying is the respect for women in the society is sacrosanct. Our ancients had said, Yatra naryashu pujyante ramante tatra devata. where the women are prayed or worshipped, gods live there. I'm only saying for the comparison about our ancient culture and today's prescribed fundamental duty and various other legislations. Now, you see, with regard to this excellence, I will just tell you, in AIMS case, the court said that AIMS is a different kind of institution and it's meant to develop the excellence in the medical students. And the individual duty collectively put become the state's duty to provide the sphere for excellence, to provide that kind of education in such an excellent institution and not to dent its quality. Therefore, the first time the court proclaimed sometimes a fundamental duty can be a facet of fundamental right or fundamental obligation for the state. Having said this, now let me go to this facet, which is extremely necessary to understand in today's context. To safeguard public property and abjure violence. We have been taught ahimsa paramo dharma. We have to follow it. We are not to be involved with any kind of social violence. No citizen is entitled in law to take law onto his own hands. That is what the Supreme Court has said in the mob lynching case. And here, the Constitution casts a duty on a citizen to abjure from violence. It also lays down a prescription not to destroy public property. While I was in school, there used to be a debate. Why do people destroy public property? To my young mind, it struck. And I said, it is because when a particular property doesn't belong to you, then you do not find any difficulty in destroying it. But when it belongs to you, you have a sense of belonging or you own it, you really restrain from destruction. In this context, I will give a very interesting example. A group of young children were playing in the field. An old man clad in dhoti kurta was going on a cycle. He was riding it clumsily. He fell down. When he fell down, the children who were young roared into laughter. One of them recognized the old man. He was his father. Then all of them ran to him and helped him. Why? Because he belonged to someone. This is the attitude. And when you develop the attitude that property of the nation, property of others has to be shown due respect, and they are not to be destroyed. This is the constitutional expectation from a citizen, apart from the punishments provided in various legislations. I have touched the important aspects of fundamental duties. Sometimes people only talk about fundamental rights. I would like to say, while asserting your fundamental rights under the Constitution, which you are supposed to do and should do and must do, simultaneously, one should be conscious of one's fundamental duties. You are supposed to respect your national anthem, flag, your culture, and also as prescribed in one of the sub-articles, the mode adopted, the method adopted, the values projected during the freedom struggle. What does it mean? You must remind yourself constantly the sacrifice and the values that was adopted by the freedom fighters and how much trouble they faced to earn freedom for us. That's a sense of gratitude. And the Constitution of India expects you must reflect that attitude in your deed. I am sure the students who are hearing me, they must take a solemn pledge that they would follow fundamental duties as prescribed in the Constitution under Article 51A to be an insegregable part of their life, and they will practice it as a way of life. Thank you. Thank you very much.
Thank you, sir. We'll move towards the question answer round. Sir, there's a question from one of the participant that don't you think, sir, that the list of duties is not exhaustive as it does not cover other important duties like casting vote, paying taxes, family planning, and so on? In fact, the duty to pay taxes was recommended by the Swaran Singh community. So, sir, is it, the list is not exhaustive as such?
Is it right? That's the question.
Yeah. Yes.
I would say he is right. The list is not exhaustive. It is the duty of every taxpayer who is liable under the taxing statute to pay the tax. I will tell you a real life anecdote. There was a senior counsel in late 50s in the Supreme Court. He was a judge in the High Court of Madras, and after retiring, he was practicing in the Supreme Court. Someone once asked him, Mr. Sastry, What do you do for your country? His simple answer was, I honestly pay my taxes. I think he could not have given a better answer. One. Now, right to, it's a duty to vote. Well, you are living in a democracy. It's an obligation to vote. Democracy is one of the basic structures of our democratic body politic. You cannot remain an alien from the voting process and claim to be governed by a government what you desire. It is your singular obligation to be informed about the candidates, as the Supreme Court has said in Krishnamurti case, and also to cast vote. You cannot be lethargic. But I entirely agree, the list is not exhaustive. Similarly, I would also add with regard to population control. At one point of time, some state legislatures had brought in some legislation that a man cannot contest in a panchayat election if he has more than 2 children. The Supreme Court talked about population, the growth, and eventually said that contesting an election is not a fundamental right, and therefore the legislation is valid. I would like to add, it is the duty of every citizen to see that our population growth, the rate of growth is reduced.
Thank you, sir. We have another question from one of the participants that the fundamental duties are not enforceable by court of law. Will it not impact on the importance of fundamental duty? And since, the violation of fundamental duty is not punishable offense, will it not dilute the purpose of fundamental duty?
You see, deliberately the parliament has not made it enforceable because there are certain ideas which cannot be enforced. But let me tell you, while upholding the constitutional validity of a statute, the constitutional courts place reliance on fundamental duties. If the statute subserves the cause of a fundamental duty, the legislation is treated to be valid. Second, because it is not enforceable, that does not mean its significance or importance is undermined. When there is a constitutional expectation, the citizen is expected, he is required to follow the same. These are ideals to be achieved, and unless you follow the citizenry responsibility, can you claim, can you assert with a sense of ethicality that I am a true citizen? everything cannot be enforced. The citizen also become a participant in a democratic polity, and he must see that he is the part of governance in a different way.
Thank you, sir. We'll take up the last question now. And it is that are fundamental duties given same sanctity as that of the fundamental rights? What are your views, sir, on this?
No, they are not equivalent to fundamental rights. The last question I answered, that fundamental rights are enforceable, but sometimes, definitely in M's case, the court, taking into consideration the collective duty of excellence, cast the burden on the state to maintain the balance of the prestigious institution called AIMS. But one cannot file a writ petition under Article 32 of the Constitution in Supreme Court or under Article 226 of the Constitution in the High Court to enforce it, enforce the fundamental right. So therefore, we are not equating, but it is not less important than fundamental duties. You know why? Fundamental rights. You know why? There is a thinker called Philip Brooks. Philip Brooks has said, happiness is the natural flower of duty. I think there cannot be a better description of duty and more sanctity added to the fundamental duty. Though in law, we cannot equate with fundamental rights.
Thank you, sir. So we move towards the end of the session. Now I would request Dean DME Law School, Professor Dr. N.K. Behel, to give the vote of thanks.
Honorable Vice Chairman DME, Mr. Aman Sani sir, Honorable Director General, Mr. Justice Bhamar Singh sir, former Judge, High Court of UP, Director DME, Dr. R.K. Swami, Head of Academics, Dr. Bhavesh Gupta sir, my faculty colleagues and dear participants. I, Dr. N.K. Behel, Dean, DME School of Law, on behalf of Delhi Metropolitan Education, Noida, and the entire fraternity of the institution, first of all, extend my most sincere thanks to the Almighty God for making today's webinar a resounding success. With His blessings and grace, we are able to make this event a great success. On behalf of DME management, I am thankful to Honorable Mr. Justice Deepak Mishra sir, former Chief Justice of India. All of us know that His Lordship is a judicial statesman and has a very busy schedule of working. His Lordship has very kindly spared time for the enlightenment and enrichment of our students and faculty members. For this act of kindness of His Lordship, we, the family of DME, shall ever remain grateful to His Lordship. It was really a pleasure to hear His Lordship. The energetic personality of His Lordship pleases everyone to work with zeal and passion. We are more than thankful to His Lordship. Thanks to our Honorable Vice Chairman, Mr. Aman Sani sir. Thanks to our Director General, Mr. Justice Bhamar Singh sir, for their kind patronage. Thanks to everyone for making this webinar a great success. This webinar will remain a historic event for DME and entire legal fraternity. Thank you again, my Lord, for your kind blessings and kindness. Thank you.
Thank you.
Thank you, sir. So with these kind words, and the session has been very knowledgeable, and we've got a lot of overwhelming response today. Around 502 in number participants have enrolled and they have participated in today's webinar. So that's all. Thank you so much, sir. And we'll see you soon in DME. With the, we'll have the book launched, the ceremony done with your presence. So we'll see you soon. Hope to
Thank you.
see the pandemic end soon and have you here at DME.
Yes.
Yes. Thank you so much. Thank you all for joining. The participants can stay. We'll circulate the attendance sheet, and rest everybody can leave. Who have filled the attendance sheet already. Thank you.
Thank you. Thank you, everyone.